Hello. Hi.
We are early birds. Do you see me and hear me?
Yes, everything is okay.
Okay, thanks, because I am in a new place, in a new house, in another house.
But everything is okay.
This is my son's children room.
And I
Like,
see new hair, yes? New blonde hair?
no.
No?
It's sometimes shorter and longer, and
Oh.
I go to a hairdresser only 2 or 3 times a year, and yes, this is the light the light
Maybe,
side.
yes,
No,
because it
it's
seems
different.
a bit lighter.
Yes, it's because of the light, because there is a window in the top.
Ah, okay.
May I ask you something? Is it, can we ask deadline prolonger for the submission to the next, the second article, because the deadline is 1st of October, and it's very, very near.
Yes, but 1st October is, I think it's to me, but our deadline is October 15th. So
15?
yes.
Oh, it's good.
So
It's a good news.
yes.
Okay.
You can send me 1 or 2 days before, yes, because I need to submit it 15th.
Okay, so 15 of
Yes.
October. Okay.
But if there are any problems, so we can prolong. I don't know. We can ask, yes, if you need a bit more time.
Hello.
Hello.
Hello, Marty. I asked
Sorry for
Kasia.
sending the report so late, Kasia.
Kasia.
I absolutely forgot. Sorry about that.
No problem. I know there was vacation.
And I asked Kasia that can we prolong the deadline of the submission of the second article, because it's very, 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 very near. And Kasia said that we have to send for her on 15 of October. So the deadline, the 1st of October is for her, and for us, 15 of October.
Okay.
So it's good. It's two weeks.
Good.
2 weeks.
Let me a moment, because I need to check Paweł Zając, if the email is correct. Yes, one moment.
Okay.
A fiam gyerekszobájában vagyok. Miskolcon. Gyorsan, hello. Gyorsan megpróbáltam egy olyan hátteret választani, ami viszonylag... Mert itt azért vannak dolgok még mindig.
Nálam meg bármikor bejöhetnek a gyerekek, úgyhogy...
Hát sajnos nálam nem. Viszont a lányom ebben a pillanatban hívott, úgyhogy most gyorsan meg kell még neki írni, hogy... Szia, Nóri!
Sziasztok!
Hello!
Hi!
Hi! Nórinál van a baba.
Hi! Sziasztok!
Nóri, valamit kérdezhetek közben?
Igen.
Hogy ugye azt te nem angolul gondoltad a szakkollégiumban az óratartást?
Nem.
Rendben, mert mi magyarul csináltuk tavaly.
Persze.
Jó, mert már ne nehezítsük már az életünket.
Nem.
Köszi, Nóri.
Jaj, hát nincs mit. Még azt az oktatáshoz való jogot, azt a konferenciát kérdeztem tőled, hogy te akarsz-e azon
Ne, örülök, hogy élek, Nóri.
Jó.
Már így is úgy érzem, hogy csak a félig. Nagyon fáradt vagyok, nem bírok.
Jó.
Jó, de ha figyelj, nem jön össze a szakkollégium, hello!
Hi.
Akkor csináljuk akkor tudjuk a doktoranduszok is.
De lehet, hogy mind a kettőnek meghirdetjük.
Okay.
Jó?
Okay, so we are complete, I think. So we can start. So officially, good afternoon, dear colleagues, dear professors. I welcome you warmly at our fifth seminar organized within the research project Legal Protection of Children with Disabilities of the Justice Institute. My name is Katarzyna Roszewska. I'm an associate professor of law at the Cardinal Stefan Wyszyński University in Warsaw. And today's topic is the second part of the subject, access to selected human rights for children with disabilities. And I think there will be 6, not 7 presentations only by members of our team, because Mr. Tomasz Jastrzębski, he sent me and he wrote me that he had bad cold, so he won with us. Okay, so presentations titles are as follows. Professor Wojciech Lis, The Maintenance Obligation of Parents Towards a Disabled Child. And Dr. Paweł Zając, The Right to Social Assistance. Me, Access to Higher Education for Young Persons with Disabilities in Poland. Professor Nora Jakab, The Framework of Social Assistance in Hungary. Professor Zuzia Wopera, The Legal Status of Children with Disabilities in Hungarian Civil Procedure Law. And Dr. Marta Benius, Access to Children's Rights, The Role of National Human Rights Institutions in Hungary. So let's start. Please remember our time is limited. Professor Wojciech Lis will talk about the maintenance obligation of parents towards a disabled child. Please, Professor, the floor is yours.
Yes, thank you very much. Hello, everyone. Good to see you. The topic of my today presentation is the maintenance obligation of parents towards a disabled child. The parents' maintenance obligation towards the child is one of the most important aspects of family law. Its aim is to provide the child with appropriate support, primarily material, enabling him or her decent living conditions and full development. As a general rule, the maintenance obligation falls on both parents to the same extent. This obligation may be fulfilled in various ways, in financial or non-financial form. It should also be emphasized that the condition for the maintenance obligation does not have to be the divorce decree of the child's parents, because it results from the obligation of mutual assistance and support between family members. One could say it lies in the nature of the family life. The content of the maintenance obligation towards a child includes providing everything he or she needs for his or her physical and mental development, that is, providing him or her with the necessities of life, housing, food, medicine, but also preparation for life on their own, providing education, opportunities to develop cultural interests and talents, providing entertainment and relax. This means that the maintenance obligation cannot be reduced solely to providing material support. Fulfilling the child support obligation also includes personal efforts to raise a child, because it determines who a person will be, what he will be like, and how he will function in society. However, the younger the child, the more personal effort it requires. Of course, this involves expenses, which include the cost of extracurricular activities developing the child's interests, sports activities, tuition, tutoring, etc. But the they are not the sense of personal efforts to raise a child. These expenses are only means of supporting the educational process and important, but not the only one. The legislator did not indicate specific amounts that should be paid for the child, because the scope of maintenance benefits provided in the form of material support depends on two factors. Firstly, on the justified needs of the child. Secondly, on the earning and financial capabilities of the parents. Therefore, each case is considered individually. Although the child's justified needs should be fully satisfied, in practice, they are determined by the parents' earning and financial capabilities. Justified needs include not only elementary needs related to ensuring the child's minimum subsistence, but their essence is to provide the child with normal conditions of living and development conditions appropriate to the child's age, health condition, and intellectual level. The parents' earning and asset potential do not only include the income of assets. When specifying the maintenance obligation, the court does not limit itself to how much each parent earns or what he or she has, but each time examines what the potential but unused earning possibilities of each parent is. In short, how much he or she could earn if he or she used his or her opportunities. Since the maintenance obligation depends on the justified needs of the child and on the earning and financial capabilities of its parents. If the underlying circumstances change, the scope of maintenance benefits also may change. A change in circumstances may lead to the abolition of the maintenance obligation or to an increase or decrease in maintenance benefits. The condition for increasing the maintenance benefit is to demonstrate an increase in the child's justified needs, which is determined primarily by the process of growing up and the condition of health. This is particularly important in the context of the needs of a disabled child who often requires constant specialist care and treatment, rehabilitation treatments, or a special diet, which undoubtedly contributes to the increase in the cost of his or her maintenance. On the other hand, if the earning and financial capabilities of the child parents have decreased due primarily to difficulties related to age or the situation on the labor market, the maintenance benefit will be reduced. In extreme cases, maintenance benefits will be taken over by the alimony fund, which, however, does not mean that parents are released from the maintenance obligation towards the child. Parents have to fulfill the maintenance obligation as long as it is necessary. A court judgment specifying the maintenance obligation never specifies the date until which it will be binding on the child's parents. There are also no regulations specifying the age up to which parents are obliged to pay maintenance, it does not always end when the child reaches the age of majority or completes education. As a rule, the parent's maintenance obligation towards the child ceases only when the child achieves independence in life, which is usually combined with the possibility of taking up paid work that will provide him or her with the means of subsistence adequate to his or her needs. Therefore, parents should support the child until he or she can meet his or her justified needs on his or her own. However, if a child does not make efforts to become independent, this is the basis for demanding that the parents be released from maintenance benefits. However, there are exceptional situations. In the case of a child who is in a particularly difficult life situation resulting from illness or disability, the maintenance obligation might burden the parents for life, especially when the child is unable to work and support himself. It depends on the type and degree of the child's disability. Not every type of disability is contraindication to taking up paid work. If the type or degree of a child's disability does not prevent him or her from working, the child cannot transfer the cost of his or her living to the parents. Therefore, the question arises, how does the maintenance obligation of parents towards a disabled child differ from the maintenance obligation of parents toward a healthy child? The difference lies not only in the duration of maintenance obligation, but also in the different distribution of assistance emphasis and the scope of its intensity. In the case of a disabled child, the main purpose of the assistance provided is not only material assistance, although this is undoubtedly important due to increased health needs, but assistance is in meeting ordinary everyday needs that the child cannot always cope with due to his or her disability. That's all for today. I wanted to highlight some questions. Thank you for your attention. Thank you very much.
Thank you very much, Professor. I fully agree. My personal observation is this alimony maintenance obligations toward children with disability, I think, go beyond the normal, typical duty to support between family members. Yes. Now I would like to ask Dr. Paweł Zając with his presentation on the right to social assistance. Please, Doctor, you may start.
Thank you very much. Good afternoon, all. My today's speech about right to the social assistance for the children with disabilities in the Polish legal system. So let's move on. Polish social protection system has been constructed on the basis of specific forms of implementation, which include social insurance, social assistance, or other forms. As such, a division results from the fact that this system is open and dynamic. Therefore, there is no reason to close it in a specific definitional framework. Social assistance is an action directly aimed at the activation and independence of individuals by satisfying the necessary needs and enabling them to live in conditions corresponding to human dignity. According to Article 2, Section 1 of the Act of Social Assistance, consists is enabling individuals and families to overcome difficult life situations that they are unable to overcome using their own rights, resources, and opportunities. The element of social assistance brings social protection closer to social security, the essence of which is to provide individuals with decent living conditions and enable them to achieve self-realization. Social assistance, as emphasized by the Constitutional Tribunal in one of its judgments, is provided through the benefits that may take the form of the so-called environmental benefits, including cash benefits in the form of allowance, benefits in kind, as well as benefits in form of services or company benefits, or in the form of placement in social welfare homes. The nature of these benefits, also from the point of view of the legal position of the beneficiary, are worries. One of the entitlements to apply for social assistance benefits is disability. In the case of children with disabilities, the beneficiary of the assistance are their parents or legal or actual guardians. In terms of cash benefits for a disabled child, the first one can be pointed to the one-off benefit from the law on support for pregnant women and their families for life. According to Article 10, Section 1, the Act on Supporting Pregnant Women and Families for Life, for the birth of a live child with a certificate of severe and irreversible disability or an incurable life-threatening disease which arouse in the prenatal period of the child's development or during childbirth, a one-time benefit in the amount of 4,000 zloty is granted for this child. It is due to the child's mother or father, legal guardian, or actual guardian of the child, regardless of income. The right to a one-time benefit is determined at the request of the person entitled to receive it. The necessary prerequisites for granting the requested benefits are birth of a live child, obtaining a certificate of his illness or disability, and the period of their occurrence, the proof that the mother was under medical care, beginning of medical supervision no later than from the 10th week of pregnancy until delivery. Submitting an application without 12 months from the date of the birth of the child by an authorized person, a family member is not entitled to a family benefit abroad for a child unless the regulation of the coordination of social security system or bilateral agreements on social security provide otherwise. The child has not been placed in an institution providing 24/7 maintenance or in the foster care. There is no uniform view in the jurisprudence whether failure to meet at least one of the conditions constitutes an obstacle to granting the benefits. As indicated is one of the judgment of the Provincial Administrative Court in Bydgoszcz, it is important that the above conditions are met jointly. Failure to meet at least one of them is an obstacle to granting the benefit. However, a separate opinion of the judges can be found in another judgment of the same court, which ruled that no provision of Act of 2016 on supporting pregnant women and families for life clearly defines that the legal consequences of a situation in which a woman seeking applied for a one-off childbirth benefit underwent medical care after the 10 weeks of pregnancy. The absence of such a regulation in the Act does not mean, however, that the women who underwent medical care after the 10 weeks of pregnancy and then gave birth to a child should be automatically, regardless of the circumstances of a particular case, deprived of the right to a one-off benefit on this account. Introduction in Article 10, Section 5 of the Act of 2016 on supporting pregnant women and families for life. Additionally, condition is only intended to mobilize pregnant women to care for their own health and the only fetus. However, this is not the main purpose of the introduced statutory regulation. The validity of the above argument may be supported by the judgment of the Constitutional Tribunal, which dealt with the issue of granting a one-off allowance for the birth of a live child, a similar benefits contained in the Act of Family Benefits, ruling that the linguistic interpretation of the Article 15b, Section 5, rather it indicates that being subject to medical care no later than from the 10th week of pregnancy is treated as a necessary condition. On the other hand, the theological interpretation argues in favor of correcting the results of the linguistic interpretation and taking into account the reasons that objectively prevent the examination during the first 10 weeks of pregnancy. Therefore, having in the mind the principle of linguistic system and functional interpretation, as well in the fact that the interpretation of statutory provision must always be made using the technique of interpreting the act in accordance with the Constitution, it was not possible to interpret this article only at linguistic methods. Fulfillment of the obligation to undergo medical care by a pregnant woman cannot be assessed without determining the objective possibilities of its implementation within the period indicated by the legislator. Adoption of the opposite position would violate the constitutional orders to protect and care for the family expressed in Article 18 and 71, Section 1 of the Constitution. Another controversial issue is the determination of the legal nature of the deadline indicated for submitting an application for a benefit, which may give rise to certain legal consequences. Here too, the judiciary has not developed a single permanent line of jurisprudence. However, there is a belief that the 12-month period is a procedural right and not a substantive preclusion term, and therefore it is possible to reinstate it. It is worth noting that the amount of the one-off benefit is not included in the income when applying for other benefits, such as special purpose benefit in the event of disaster and fortunate events, benefits and material assistance granted in special cases, remuneration for care or assistance for a foreigner. However, a shortcoming of the analyzed provision may be the lack of mention of indexation of the amount of the benefits, which means that is a constant and independent of economic turmoil such as inflation. Thank you very much.
Kasia, masz wyłączony mikrofon.
Sorry again. So thank you very much. I can only add that we will have some kind, I think, new model of support family with child with disabilities because they will can combine benefit, social benefits with salary. Yes? So they will can work and take benefits. So now is my turn. I would like to present access to higher education for young people with disabilities in Poland. It's associated with the right to education for children, and I presented this topic in the seminar in August. The right to higher education, as well as the right to primary and secondary education, is protected by the Constitution. The scope of this protection is different, of course. The constitutional standard of protection for students with disabilities is high. It goes beyond the international standards, but statutory law doesn't look as good. Statutory provisions implement constitutional obligations, but don't implement the latest international obligations. The main practical problems are the poor quality of education at the secondary school level, I mean education for children with disabilities, barriers, lack of accessibility of universities, and unprepared lecturers to work with a diverse group of students. What is the constitutional standard in Poland? The same provision applies to general and higher education. The right to education applies to everyone, not just children. Therefore, also extend to higher education. The Constitution says everyone has the right, and in public school without payment, it means that public full-time studies are free of tuitions. The universities can charge, but only for certain services. Applicants, candidates may not be differentiated on the basis of any criteria other than school results. Access to public education at all levels should be universal and equal, and system of financial and organizational assistance are created not only for pupils but also for students. And the last provision in Constitution also guarantees the autonomy of universities. We usually look for the strengthening of certain constitutional rights in its other provisions. I don't know how human rights are written in the Hungarian constitution, but we have provision that guarantee rights in certain areas, like, for example, in education, but also we have special protection for certain groups, like children, persons with disabilities, families, sometimes farmers, yes, or refugees. So when we discussed children's education rights, also Article 72 on child protection strengthened the right to education. In this case, this provision doesn't apply, but however, Article 69 still applies to students with disabilities because it applies to generally to persons with disabilities. And according to this article, public authorities shall provide them aid and social communication, also adaptation to work. However, aid only in securing their existence is guaranteed, not in realizing their full rights on equal terms with others. At the level of higher education, social support is important, but also accessibility of facilities, personal assistance, reasonable accommodation, and this in turn is guaranteed by binding international regulations. Worth mentioning at this point is also Article 73, our Constitution, which constitutes freedom of scientific research, so it applies to PhD students, for example. Our standards of protection are also set by ratified international agreements, especially CRC and CRPD, and we know it. I've talked about international standards before in various contexts, including education, so I won't repeat them, but only briefly in the field of higher education. For example, the Committee on Economic, Social and Cultural Rights, in its General Comment number 5, Persons with Disabilities, of 1994, in the paragraph about the education, repeated after the standard rules of equalization of opportunities for persons with disabilities, that states recognize the principle of equal primary, secondary, and tertiary educational opportunities for children, but also for youth, adults with disabilities, and ensure that necessary equipment, support are available to ensure persons, generally persons with disabilities, achieve the same level of education as their peers without disabilities. And a few words about the Convention on the Rights of Persons with Disabilities. What does Article 24 provide for higher education? States recognize the right of persons with disabilities to education and shall ensure an inclusive education system at all levels and lifelong learning. All of this not only for education, but also for the development of personality, talents, and creativity. So features that we develop throughout our lives. States also shall ensure that persons are able to access general tertiary education, vocational training, adult education, and lifelong learning without discrimination. And to this end, states shall ensure reasonable accommodation. It means that the right to education on an equal basis is clearly guaranteed to adult students in higher education. And the appropriate measures indicated in this article apply not only to general education, but also to higher education, only example facilitating the using of Braille. But the convention also indicates the promotion of the linguistic identity of the deaf community, and I can praise at this point the University of Warsaw, because it started master studies in sign language for interpreters, teachers, and researchers of the culture of the deaf community. So we have this type of study in Poland from US. The most important legal act, the Act on Higher Education and Science, this is quite new, but it replaced an earlier one containing similar provisions in the discussed area, and it obliges, in addition to providing education, to creating conditions for students with disabilities to fully participate in the process of admission to the university, education, and conducting scientific activity. Financial resources shall be allocated to this task, and universities must have the separate support fund for persons with disabilities, so dedicated for this group. The Act guarantees the right to a scholarship for people with a disability certificate, and this scholarship is independent from other forms of support and doesn't depend on the social situation or income, such as social scholarship. Social benefits are available to all low-income people, and students with disability can apply for this support like others. The regulations of special scholarship for the students with certificate are very detailed. They say how long you can receive the scholarship, what happens if you start another studies, etc. And the amount is regulated by our law, but only for PhD students, because the monthly scholarship is related to professor's salary. For students, regular students, it varies depending on the number of students with a disability certificate and financial capability of the university. Students with disabilities are subject to the same requirements, but they are entitled the same rights. In order to guarantee them support at universities, offices for students with disabilities are established. These offices provide services to the students. The main condition for receiving the assistance is linking the disability with difficulties in implementing the study program. The services are also dedicated to people who do not have a disability certificate, if they are chronically ill or temporarily disabled, and who, due to their health condition, are unable to complete the standard study plan. Students may apply for individual organization of studies. The university's offices give them opinions and initiate solutions to facilitate their studies, in particular by an assistant during classes and exam, enabling participation in the classes of a sign language interpreter or some kind of assistance from family members even, extension of exam time, changing the form of the exam, and other facilities according to the individual needs. But these provisions result only from the study regulations. We don't regulate it in our act, statutory act. I would also like to draw attention to several other legal acts. For example, we ratified Marrakesh Treaty, and European Union also, so we changed our copyrights law of 1994, and this is general copyright law, but permitted use provisions are particularly useful for learners and for students, pupils with disabilities. It is permissible to use already disseminated works if the use related to the disability is not of a commercial nature, and it's undertaken to the extent resulting from the nature of the impairment. We also have some regulations that apply to various facilities and spaces, including higher education. For example, construction law of 1994, accessibility requirements are imposed on the design of facilities open or serve the public. So it means new buildings, public and private, must be designed in accordance with universal design. Other act, the road traffic law, provides that person with disability is exempt from fees for the use of a public road or internal road, enabling access to public utility facilities like public administration, culture, healthcare, religious buildings, and also education and higher education facilities. And similar provisions in the Act on Social, Vocational Rehabilitation and Employment of Persons with Disabilities, because it contains a provision that a person with an assistance dog has the right to enter, again, to public utility facilities, including higher education facilities. When you think about the cases, CARD cases concern rather administrative matters related to, for example, decorate payment of a scholarship or the control of university accessibility. They don't involve discrimination, which doesn't mean that it doesn't exist. I know from practice that students sometimes complain about ableist comments and even questioning their ability to study a specific field of study. But research has shown that these are singular cases. Most often, universities teachers say they cannot cope with students with mental or functional disorders and autism spectrum disorders. And other problem, there are no statutory accessibility standards for universities, apart from benefits like scholarship. Those applicable to public institutions are of general nature, so they don't even apply to private universities. And I said at the seminar where I present accessibility, our regulations don't generally oblige private entities to be accessible. So accessibility regulations for private entities and for private universities also are selective. At the end, only the example of Hungary, because the example of Hungary became the basis for regulating the availability of banks and changing banking law, because Hungary signed an optional protocol and blind citizens complained to the committee about an availability of ATMs. So it's provide to changing banking law. And thank you. Because Dr. Jastrzębski didn't join us, so let's move on the speakers from Hungary. I would like to ask Professor Nora Jakab to speak about the framework of social assistance in Hungary. Please, Professor, the floor is yours.
Thank you very much. Dear colleagues, this month and next month, I'm going to speak about the social security and social assistance and the framework of these regulations in Hungary. For persons with disabilities to avoid exclusion and access essential services, it's very crucial, and they must have not only the resources needed by those without disabilities, but additional spending and other forms of support and accommodations to overcome these barriers are also very important. At this point, I would like to highlight the costs of social security and social assistance. Because in addition to having to spend more to achieve the same standards of living, they are the direct costs. Persons with disabilities also tend to earn less income due to barriers in employment and opportunity costs incurred by family members providing support. And together, those additional expenses and foregone income constitute the disability-related costs, which prevent them from economic opportunities and achieving a similar standard of living and participation, and they are called indirect costs. However, these direct and indirect costs, including social security and social assistance, it creates a vicious circle that social protection can help break with a well-designed combination of schemes. In August and in July, I have been carrying out researches on what is a well-designed combination of a social security scheme like. And finally, I came to the conclusion that social protection policies are powerful tools to achieve immediate relief for poor children and their families. And social protection provisions can trigger virtuous cycles of improved income generating capacities of the parent in cases that households are engaging in higher risk, higher return activities, as we have also heard in the first two presentations. By providing a steady, predictable source of income, social protection benefits enable households to avoid harmful coping strategies, such as pulling children out of school, cutting spending on food, or selling productive assets when facing a shock. Within social protection system, a broad range of interventions can benefit children and families, as we have already seen in the police system. Interventions designed specifically to benefit children include universal or targeted, conditional or unconditional, contributory or non-contributory child or family cash benefits, school feeding, vaccination or health programs, and other in-kind transfers, such as free school uniforms or school books, exemptions of fees for certain services, such as healthcare or childcare, social security benefits provided to mothers, fathers, as we have seen and we have heard from the second presentation in Poland, and other caregivers during leave of absence from employment in relation to a dependent child. Childcare services, early childhood education, and education until the minimum age for admission to employment according to national legislation. And also, we must count on tax rebates or tax reductions for families with children. The availability to both women and men of adequate parental and childcare leave benefits, childcare services, and early childhood education are essential in guaranteeing the income security and well-being of children. And Professor Rosewska, we have heard quite a lot about the education and the right to education. I also experienced that in the Hungarian literature, the right to education is a very highlighted area. However, when we come to the issue of social security or the social security of disabled children, we can find hardly any literature in the Hungarian document. Measures adopted by employers to facilitate sharing work and family responsibilities for parents with children also play a key role, but this is a work-life balance issue and a labor law issue. Another important factor for children's and women's well-being is maternity benefits, as we have also heard in the Polish system. However, I was striving to find what a child-sensitive social protection system means. What are the characteristics? So, when we try to analyze the Hungarian social security and social assistance system, then what are the characteristics which we have to focus on? It's very important that institutional capacity and resources are available to efficiently and effectively to implement appropriate instruments. What kind of instruments are these? First, social transfers, predictable, regular transfers, cash or in kind, from government and community. Second, social insurance that support access to healthcare for children, as well as services to support communities. Thirdly, social services, family and community services to support families and promote youth and adult employment. Alternative care for children outside family environment. And fourthly, policies, legislation, and regulation. It protects families' access to resources, promote employment, and support them. This is the framework. In Hungary, the protection of children with disabilities is guaranteed by several legal acts. But it is a bit misleading because we have got the general legal framework, but in practice, it doesn't work well. All children have the right to the level of protection and care necessary for their physical, intellectual, and emotional development, as we have heard in Poland as well. However, the focus at national level is on areas such as reducing child poverty, improving the situation of families with children in general, and reducing disadvantage and exclusion in rural areas, but it is focusing on the schooling issue. The current social welfare system provides help and support to families with children with disabilities, but there are many limits to the resources available. And families living in disadvantaged regions of the country often face problems in accessing basic health and social services. And even at the community level, there are no personnel who could help these families professionally. Legal protection for children with disabilities in Hungary is provided, of course, by the fundamental law. It prohibits discrimination on grounds of disability. But we do not have any article on the discrimination against the children because of the disability. The legal framework, of course, is in line with the UN Convention on the Rights of the Child and the CRPD. But this is the general framework and the theory. The most important piece of legislation in the field of the children's rights is the Child Protection Act. We also have a national strategy for children, which states that the rights of the child and the best interest of the child must be a priority. And we have also heard a lot about it in Marta's presentations. Although the legal framework guarantees the rights of children with disabilities, implementation is difficult, as I have also mentioned. There are major gaps in the following areas: effective child protection alert system, and of course by establishing the responsibilities of the authorities in the case the child needs protection, access to social services. And every time when we talk about social services, the literature talks about healthcare and education, but there are problems in other fields as well. Reduction of institutionalization, school segregation, and multiple discrimination against Roma children with disabilities, and lack of resources for children with disabilities. These children with disabilities do not always have access to social services and education, mainly because they are most of the time institutionalized. It is essential that more resources are allocated to healthcare and social services to improve their quality of life. We also have another important legislation for persons with disabilities, which is an act on the right of persons with disabilities. This is the Disability Act and the National Disability Program. However, the fourth pillar of a child-sensitive social security system, which is policy and regulation and legislation, do not really focus on Disability Act and the National Disability Program, as I discern it. Very few specific provisions apply to children with disabilities in the Hungarian system. Most of the legislation deals either with persons with disabilities or with children. There is no generally applicable legislation in this area. And as I mentioned, education, discrimination are the most frequent issues. We have a national strategy, The Better for Children, till 2032, and it sets out the task to be undertaken to reduce child poverty and social exclusion. In Hungary, children with disabilities face first and foremost the institutionalization of home or family care. And in July, I have been already talked about this problem. The replacement of large institutions providing care for people with disabilities has been on the agenda in recent years, but unfortunately, its impact has not yet been felt. According to the Child Protection Act, children with disabilities have the right to special care to assist their development. Support for families with children with disabilities may be provided in cash or in kind. Benefits in cash include family allowances. It is mainly education allowance, childcare allowance, care allowance, reduced nursery school meals. Other forms of assistance include daycare for children, free school books, medicine, medical aids, daycare for disabled people, parking cards, and travel discounts. The Act on Family Support and other laws provide cash benefits for families with children with disabilities, and it is always a higher family allowance when you have a child with disability. But I must say that the amount is rather ridiculous. Despite the legal provisions to this effect, access to conditions that support the physical, social, mental, communicative, and personal development of children with disabilities is not always ensured at an early age due to regional disparities and the lack of professionals, as I have mentioned. Pathways to services for the sick are unclear, so parents often get lost in the institutional system. Nurseries care for children under 3 years and contribute to their early development. But what happens with the children with disability? They can stay in nurseries up to the age of 6, according to the opinion of an expert committee. In schools for children with special educational needs, as Marta was also talking about that earlier, part of the time must be devoted to medical and educational rehabilitation. And children in state care are educated in special homes if they are unable to attend general education. This is a general framework when, and if we try to say whether our social security system is a child-sensitive social security system according to the literature, we can, I think, conclude that we are far from it and we have to improve the Hungarian system to it. Thank you very much.
Thank you very much, Professor. Maybe only one example from Poland. Yes, the children with special needs, they, for example, they go to school, I think 1.5 hours, more than 1 hour each way before they arrive to school, because the transport, this special transport, collect children from many districts, yes?
Mm-hmm.
And even in so rich, such a rich city like Warsaw. Our next speaker is Professor Zuzia Vopera with the presentation on the legal status of children with disabilities in Hungarian civil procedural law. Please, Professor.
Thank you so much. Dear colleagues, I think I will continue Nora's presentation on some issues because there's connecting points, we have some connecting points. So in the second part of my research, I undertook to examine the legal status and rights of children with disabilities in current Hungarian substantive and procedural civil law. In my previous presentations, I will deal with the international and European Union legal regulation on the right of children, including children with disabilities, to participate in civil proceedings. Based on the relevant explanation and literature, we established that the Article 12 of the CRC introduces the fundamental principle that all children capable of forming a view are entitled to express the view and have it taken seriously. It is a right that is particularly challenging in societies where children's views tend to be largely disregarded. The challenge is far greater for children with disabilities who are widely assumed to lack the capacity or experience to make a significant contribution. The CRPD recognizes that children with disabilities are commonly denied the right to be heard. Article 7 therefore obliges government to ensure that they are provided with disability and age-appropriate assistance to realize the right on the equal basis with others. The Committee on the Rights of the Child has provided a detailed analysis of how to interpret Article 12 of CRC and has also provided guidance on its implementation with regard to children with disabilities. Children with multiple and profound disabilities, including very young children, are able to form views, although they may need appropriate help in expressing them. What Article 12 requires is that adults commit to hearing those views with respect. Implementation of Article 12 requires recognition of non-verbal forms of communications, such as body language, facial expression, touch, sign language, play or drawing, and painting. In my last presentation, I outlined the regulatory framework of Hungarian law in the area of children's rights to participate in civil proceedings, and I would like to continue this issue in my today's presentation. According to Article Roman 5 of the Fundamental Law of Hungary, everyone shall be equal before the law. Every human being shall have legal capacity. By means of separate measures, Hungary shall protect families, children, women, the elderly, and those living with disabilities. The Fundamental Law of Hungary also highlights certain groups to be protected. This includes families, children, women, the elderly, and the disabled persons. In Hungary, we can find out about the proportion of people with disabilities and the type of their disability from the data of the Central Statistical Office. Based on the data from the 2016 census, 408 or 22 people live with some forms of disability in Hungary. Among them, more than 22,000 are children under the age of 14, and 34,000 are children and young adults between the age of 15 and 29. From this, it can be concluded that a significant number of disabled persons belong to the older age group. Based on the authorization of the Fundamental Law of Hungary, as Nora said, separate act, the Act on the Rights of Disabled Persons and Ensuring Their Equal Opportunities, the Disability Act, regulates the rights of disabled persons. This act declares that disabled people are equal members of society with equal dignity, who are able to live with the rights and opportunities that belong to everyone, only with significant difficulties or not at all. The purpose of this act is to define the rights of disabled persons, the means of enforcing these rights, as well as to regulate the complex rehabilitation to be provided to disabled persons, and as a result of all this, to ensure equal opportunities, independent living, and active participation of disabled persons in social life. Among the basic principles, this act states that the state is obliged to ensure the enforcement of the right of disabled persons and the operation of the institutional system that compensates for the disadvantages of disabled persons in accordance with the current opportunities of the national economy. Due to their condition, disabled persons are less able to live with the rights they deserve equally with everyone else. So it is justified that they should be given an advantage in every possible way. As I mentioned earlier, both the Child Protection Act in guardianship proceeding and the Civil Code provide the opportunity for the child who has the sufficient understanding to express views in all proceedings affecting them. This possibility must also be ensured in the case of children with disabilities, based on both international and Hungarian law. In the following, I will present the relevant Hungarian private laws regulation. The basic rules for parental custody are found in the Civil Code in Book 5, in the so-called Family Law book. In Hungarian law, in accordance with international legal regulation, a minor is a person under the age of 18. Minors under the age of 14 shall have no capacity to act. Minors shall have limited capacity to act if they have reached the age of 14. A minor child under the age of 18, regardless of whether he is disabled or not disabled, is under parental custody. Special rule that minors having reached at the age of 17 may be placed by the court under the rules applying to adults under custodialship, limiting their capacity to act partially or in full. According to Civil Code, a minor child shall be subject either to parental custody or guardianship. Parental custody includes the right and obligation to determine the minor child's name, to care and bring up the child, to determine the place of residence and manage the minor child assets, as well as the right to appoint a guardian and to exclude someone from being a guardian. The content of parental custody includes the obligation to legally represent the child. The parents exercising parental custody shall have the right and obligation to represent their child in his personal and property matters. This means that the parent or guardian has the right to initiate a lawsuit on behalf of the minor, and parent or guardian provides the legal representation of the child in the action as well. Those actions where there may be a conflict of interest between the parents and the child are, of course, an exception to this provision. This can happen, for example, in proceeding to establish parentage or in proceeding to terminate parental custody. This issue is properly settled by substantive and procedural rules. If the parent, who is the statutory representative of the child, cannot act in the child's affair due to the conflict of interest or any other obstacles, the guardianship authority shall appoint an ad hoc guardian for the child. The appointment of an ad hoc guardian may be applied for by an interested party, any authority, or it can also take place ex officio. For the purpose of the appointment of an ad hoc guardian, the parent shall be required to notify without delay the guardianship authority of the parents not being allowed to act due to the grounds specified earlier. The ad hoc guardian shall have the same competence as the guardian in the case. And let's look at the relevant rules of the Civil Procedure Code. According to the new Hungarian Civil Procedure Code, which entered into force the 1st of January 2018, if a person may enjoy and be bound by rights and obligations under the rules of the civil law, he may be party to a court action. This is called the procedural capacity to be a party. A person may participate as a party if he has full capacity to act under the rules of civil law. Since civil procedural law doesn't recognize limited procedural capacity to act, a person under age of 18 doesn't have procedural capacity to act, even he has already reached the age of 14. A party shall act through the statutory representative in the action if the party doesn't have any procedural capacity to act. Therefore, as a general rule, that parents act as the legal representative instead of the child who doesn't have the procedural capacity to act. Therefore, the procedural regulation do not make difference regarding children under age of 18 according to whether the child is disabled or not disabled. If a child doesn't have statutory representative, the court shall appoint a guardian ad litem for a party if the party has no capacity to act and doesn't have a statutory representative. So, for example, in the event that the minor child has neither a parent nor a guardian. In family law procedures, such as in matrimonial proceeding, parental custody proceeding, special rules apply to the representation of the child and the participation of the minor as an interested party. In actions related to personal status, special rules apply to the legal actions of children who have reached the age of 14. According to the section of Civil Procedure Code, a person having limited capacity to act, whose personal status is affected by the action, shall have full procedural capacity to act during the action. This means that a child who has reached the age of 14 can make a valid procedural statement if he is a party in an action related to his personal status without the consent of his legal representative. This is the parent or the guardian. Although we must add that the child is rarely to be a party in these actions, related person in personal status, but it can happen, for example, also in action to terminate parental custody, where the child who has reached the age of 14 can also initiate this procedure. It's important to emphasize that the civil procedure code doesn't make difference between the regulation for children in this area as well, depending on whether the child is disabled or not. As I talked about earlier, the Civil Procedure Code contains precise procedural rules for the hearing of minor children as an interested person in actions related to personal status, which are considered to be very progressive provisions of the Hungarian procedural law. At the same time, the Hungarian Civil Procedure Code doesn't contain any provisions of the form of disability appropriate assistance provided for in the paragraph 3 of Article 7 of the CRPD, which has also been ratified, of course, by Hungary. Neither the parent providing the legal representative of the disabled child, nor the guardian ad litem appointed by the court, nor the ad hoc guardian appointed by the guardianship authority need to have any special expertise. It is also worth emphasizing that the supported decision-making that has existed in Hungary since 2013 cannot be used to support the disabled children because it only supports adults with disabilities. So we can state it that Hungarian procedural law regulation must be developed so that children with disabilities also have a genuine and effective opportunity to participate in the proceeding. For this, it is necessary to provide the disability appropriate assistance who can use their expertise to help disabled children express their views in the civil procedures. Thank you for your kind attention.
Thank you, Professor, for your insight into civil procedure in Hungary related to children with disabilities. And last speaker, Dr. Marta Benius. She will represent the access to children's rights, the role of national human rights institutions in Hungary. Please, Doctor.
Thank you. Good evening, dear colleagues. My first paper was on examining the child rights perspective towards children with disabilities. I concluded that there is tangible deficiency in the Hungarian system that was now underlined by both Nora and Zsuzsa. So the depository and the shaper on the state level of this perspective might be a specialized institution that has the professional knowledge and the resources to shape such perspective. Therefore, the second part of my research concerns the role of specialized national human rights institutions in the protection and promotion of the rights of children with disabilities, and on how, by their special competences, may ease the access to children's rights for children with disabilities. The question that naturally arises here is whether a specialized human rights institution on children's rights could contribute to a better protection and promotion of the rights of children being on the periphery, such as children with disabilities, and by their special competences enable their more effective access to their rights. The last presentation I gave concerned the national human rights institutions in general and highlighted their specialized from the ombudspersons for children's rights only in a small detail. Now I would like to make a few comments on what the Committee on the Rights of the Child has to say in this regard, and then I would like to put the focus on Hungarian legislation. In the UNCRC, there is no direct reference to national human rights institutions and their monitoring role in the implementation of children's rights. Article 33 of the UNCRPD already mentions the important role of national human rights institutions in national implementation. This might have a purely historical reason, as the CRC was adopted in 1989 on the international level, and the importance of the national human rights institutions was strengthened in 1993 in the Vienna Declaration and the Paris Principles that show the the basis and the basic standards of national human rights institutions were adopted in 1993 by the General Assembly. The Committee on the Rights of the Child deducts the alleged obligation of the states to establish specialized national human rights institutions from Article 4 of the UNCRC, which says that state parties undertake all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the Convention. The CRC Committee issued a general comment to direct states in establishing these institutions. Firstly and foremostly, the general comment states that there should be a national human rights institution designed to protect children's rights that is constitutionally entrenched or at least legislatively mandated. National human rights institutions should be accorded such powers as are necessary to enable them to discharge their mandate effectively, including the power to hear any person and obtain any information and document necessary for assessing the situation falling within their competence. These powers should include the promotion and protection of the rights of all children under the jurisdiction of the state party in relation not only to the state but to all relevant public and private entities. The national human rights institution establishment process should be consultative, inclusive, and transparent, initiated and supported at the highest levels of government, and inclusive of all relevant elements of the state, the legislature, and the civil society. In order to ensure their independence and effective functioning, national human rights institutions must have adequate infrastructure, funding, professional staff, premises, and freedom from all financial control that might affect their independence. While the committee acknowledges that this is a very sensitive issue and that state parties function with varying levels of economic resources, the committee believes that it is the duty of the states, even though there is not a direct reference in the Convention, to make reasonable financial provision for the operation of national human rights institutions in light of Article 4 of the Convention. The mandate and powers of national institutions may be meaningless or the exercise of their powers limited if the national institution does not have the means to operate effectively to discharge its powers. National human rights institutions might have the power to consider individual complaints and petitions and carry out investigations, including those submitted on behalf of or directly by children, also by children on the periphery, so children with disabilities. In order to be able to effectively carry out such investigations, they must have the powers to compel and question witnesses, access relevant documentary evidence, and access places of detention. They also have a duty to seek to ensure that children have effective remedies, independent advice, advocacy, and complaints procedures for any breaches of their rights. Where appropriate, national human rights institutions should undertake mediation and conciliation of complaints. National human rights institutions should have the power to support children taking cases to court, including the power to take cases concerning children's issues in the name of the national human rights institutions, and to intervene in court cases to inform the court about the human rights issues involved in the case. National human rights institutions should be geographically and physically accessible to all children, including children on the periphery, so children with disabilities. In the spirit of Article 2 of the UNCRC, they should proactively reach out to all groups of children, in particular the most vulnerable and disadvantaged, such as but not limited to children in care of detention, children from minority and indigenous groups, children with disabilities, children living in poverty, refugee and migrant children, street children, and children with special needs in areas such as culture, language, health, and education. National human rights institution legislation should include the right of the institution to have access in conditions of privacy to children in all forms of alternative care, and to all institutions that include children. That could be a basis or a starting point. Unlike, for instance, in Poland, in Croatia, Serbia, or Slovakia, in Hungary, there is no specialized human rights institution that would merely focus on the rights of children. The role of national human rights institutions that is established in line with the Paris principles that I already mentioned in my in the beginning of my presentation is taken by the Office of the Commissioner for Fundamental Rights in Hungary. The legal basis of the office may be found in Article 30 of the Fundamental Law. These are purely general provisions. It says that the Commission for Fundamental Rights shall perform fundamental rights protection activities. His or her procedures may be initiated by anyone. The Commissioner shall investigate any violations related to the fundamental rights that come to his or her knowledge or have such violations investigated and shall initiate general or specific measures to remedy them. The other provision talk about the operation and the establishment of the office of the commissioner. One might see that these are general provisions, and on the constitutional level, there is no reference to children's rights or disability rights in connection with the office of the Commission of the Fundamental Rights. The detailed legislative background of the office is laid down in Act 111, 2011, on the Commissioner of Fundamental Rights. Article 1 of the Office of the Commissioner of Fundamental Rights says that the rights of the child should have a special attention. Besides this provision, there is no reference to children's rights. The CRPD separately mentioned as the Commissioner of Fundamental Rights is appointed as the institution being responsible to accomplish the task given by Article 33, paragraph 2 of the UN CRPD. This is detailed in Chapter 3 per D. The procedure and competences of the Commissioner of Fundamental Rights are detailed in Chapter 3. According to this, anyone can apply to the Commissioner of Fundamental Rights if their opinion, public administrative body, local government, nationality, self-government, a public body operating on the basis of compulsory membership, the Hungarian Defense Force, law enforcement agencies, other bodies acting in public administrative powers in this capacity, investigate authority or the investigative body of the prosecution, notary public, public service body, activity or omission violates the fundamental right of the person making the application or involves a direct threat to it, provided that the available administrative remedies, not including the administrative lawsuit, have already been exhausted or no legal remedy is provided for him or her. The Commissioner of Fundamental Rights may not investigate the Parliament, the President of the Republic, the Constitutional Court, the State Audit Office, the Court, as well as the Prosecutor's Office, with the exception of investigative body of the Prosecutor Office, his activity. Even though we can see that the competences might be wide, but they still leave many breaches of children's rights unseen and undetected, especially the rights of children on the periphery. If we look at the organizational map of the office, we may see that there is one department that deals with the equality issues and children's rights together, and a sub-department that concentrates on children's rights. This is a small department which only from a human resources perspective have not enough capacity to deal with breaches of children's rights in the whole country. If we browse on the site of the office, we find almost no documents that would deal with the rights of children on the periphery. There is lack of capacity that such monitoring activity is performed. The CRC committee, in their concluding observations, have noted in 2 rounds that Hungary should design a separate authority with a mandate and adequate resources, both financially and regarding professional staff, that would focus on children's rights. The current status is surely not satisfying this requirement. Even if we do not change the current structure of the Commissioner for Fundamental Rights in Hungary, it could be given real thought to appoint a deputy ombudsperson on children's rights, as there is a deputy ombudsperson on minority rights and future generations. This would give a capacity to intervene more in the rights of children on the periphery, which are breached. In my Delega Frenda proposals, I will deal with the powers and mandate of such institution. Thank you very much for your kind attention.
Thank you very much. I'm not sure if I understood properly, but we have ombudsman in Poland for children, yes?
Yes.
Okay.
I know that
Okay.
you have, and it's very wide, with very wide competences, one of the widest in Europe. So the powers are very strong in Poland because as I know, he can also intervene in court cases,
Yes.
also in constitutional court. So it's a very wide mandate that it
Yes.
has.
Thank you very much. I think that was our last such substantive seminar, because next month we will summarize our research at the seminar. And maybe briefly about the progress of our project. Our monograph is already in preparation. And now please remember about articles. We must submit the text by October 15th. And we must organize the event promoting the project until October, last October, yes. We should remember that this event must be documented via photos or some kind of paper or recording, yes. It could be, for example, meeting with students or some kind of paper information. Okay, so thank you very much, and see you next month, yes?
Bye.
Thank you.
Thank you very much. Thank you. Marta, mogę na 2 słowa?
Tak.
Słuchaj, tam jutro będziesz gdzieś dostępna wieczorem, żebyśmy się tam na 5 czy 10 minut mogli?
Kiedy dzisiaj?
Jutro.
Jutro, tak, mogę, będę.
Dobra, to weź tam jakiś link podeślij, dobrze?
Dobrze, to porozmawiamy o której.
Dobra, thank you very much. See you.
Thank you, bye.
See you. Bye.
Thank you.
Have a nice evening.
Yeah, you
Yes.
too.
We are retired, I saw.